Welcome, I'm Todd Raffel with ERE Media. If you don't know where to find us, you can find us at ere.net on the internet, ere.net. I'm here talking about healthcare with Christina. Tom is with the law firm Ogletree Deakins, appellate litigator at Ogletree Deakins. And we're talking about a part of the healthcare reform issue and case that you may not have heard and read as much about, and that is once the case is decided, what happens next for recruiting and human resources? What does that mean? In very short, we're not going to talk really about the case, but in very short, what's this case about? In case you're curious, if you have not been reading about it, the case before the Supreme Court is about the law that Obama signed. The case hinges on basically three things: is there a tax, and if so, maybe this case needs to be heard later after the tax is enacted. Is there an unfunded liability on the states revolving around Medicaid? Lastly, and probably most importantly, is the mandate that you have to buy health insurance, which is more or less part of the law that you have to buy health insurance or pay a penalty, is that constitutional under the Commerce Clause? So that's the case. So the question for you, Tom, is, of course, we don't know how it's going to come out, probably around June. But depending on what happens, the law's upheld, the law's overturned, or maybe part of it's scrapped, what could that possibly mean if we could project for recruiting? For example, just an example, if the law is upheld, does that probably in the end encourage far more employees to be in these government-run exchanges? Employers have far less necessity to provide health care, and that makes benefits less of a recruiting lure. Anyhow, what do you think could happen to recruiting in HR under the laws, the court's determination?
I think you're absolutely right that if the individual mandate is upheld, then the law as a whole is almost certainly going to be upheld. And that means that the exchanges will go into effect on January 1, 2014. And I think they will compete with some employer plans for some kinds of coverage from some employees. And to that extent, they will make medical coverage less important, at the margin at least, for many employers. The big question is, or the bigger area of uncertainty is, what happens if, as many pundits are predicting, the individual mandate is struck down, and there the uncertainties arise mostly from the question, well, in that case, what else might the court strike down with it? As your viewers, I'm sure know, the government's position is that if the mandate goes, then at least the community rating and the guaranteed issue provisions also have to go. But the court appointed an amicus who did a wonderful job of arguing that no, the court could just strike down only the individual mandate and leave everything else in place. And that, I think, might pose a dilemma for insurance companies, because they would still be subject to these guaranteed issue and community rating rules, which they would have to abide by if they wanted to participate on the exchanges. And yet the push for healthier individuals to get coverage would be missing. That could pose a very serious problem for insurers, which in turn would make the exchanges less effective. And from a recruiting point of view, it would be much more business as usual than I think the act originally anticipated. Then, of course, there's the possibility suggested by some that the entire act might have to be invalidated. And there, of course, we really would be dealing with business as usual except, of course, to the extent that employers have already built in some of these pre-2014 requirements into the terms of their plans.
When we say business as usual, it's an interesting phrase because from what I understand, and maybe you have a different take on this, we really don't know what the business as usual is going to be under the law. We don't know. I've read some things about these huge numbers of employers might consider dropping health insurance, or maybe like a startup type company that's on the verge might decide not to offer it. I've also heard other people say, no, it's not going to cause employers to drop insurance or to not offer insurance because it's such a powerful recruiting lure. So under the law, if it goes in effect, it seems like a big unknown right now. Is that right?
I think that's a fair statement. And what I'm seeing just from reading in the media and talking to people is that a lot of this depends upon the size of the company and to a great extent the business area that it's in. Benefits are an extraordinarily important recruiting tool in some occupations and not necessarily as important in others. An example of an area where it's not quite as important is any industry that relies heavily on part-time or seasonal workers. Many of those people approach the job market without any expectation of healthcare coverage. To them, it might be more important to be able to participate in a 401k plan, for example, because maybe they're providing a second income for their families. The one thing I think we can say is that if the act as a whole is struck down, unless there has been some other shift in the economy that would cause things to be different, the recruiting considerations should be roughly like they were in 2011. I'm not suggesting that that was not a dynamic situation. Clearly it was. But the act will no longer function as a driver of the answer to this recruiting question.
Tom, interesting, and thank you. We're going to have to probably reconvene in June, probably, when this law is, when the court decides on the law. Maybe we can talk about what then we think will happen. Until then, I really appreciate it, Tom Christina from Ogletree Deakins, appellate litigator at the employment law firm of Ogletree. Thanks, Tom.
Absolutely. Happy to do it.